Hello. Jurors walking off to take phone calls while a remote trial is supposed to be taking place. Plaintiffs chatting with jurors while the judge and lawyers are in a private sidebar during a Zoom trial. Hackers infiltrating Zoom and streaming pornography into the courtroom in the middle of a court hearing. I wish I could say I'm making this up, but I'm not. These things have all actually happened in recent months while trial courts have struggled to resume business as usual during the COVID-19 pandemic. I'm Jim Yukevich. This is the latest in our series of webcasts about jury trials in the age of COVID. Today, I'm going to discuss some of the problems created when courts throughout the nation attempt to hold jury trials while trying to follow COVID-19 safety precautions. The closures due to the pandemic have lasted longer than any of us originally expected. And let's be honest, there may be no end in sight. Litigators like myself have had to adapt our practice in ways we never thought possible just a year ago, such as Zoom depositions and Zoom mediations. Here in California, the Orange County Superior Court is even streaming each day's proceedings in each of its trials, amazingly, on YouTube. If you ask me, the COVID-19 pandemic has brought about changes to litigation practice that are going to last long after the pandemic is over. That's why my firm is embracing new technologies in order to best represent our clients under all circumstances. However, while it hasn't been that hard to get used to things like Zoom depositions, I have been thinking for a while now about whether jury trials in the COVID-19 era can really be truly safe and fair to all those involved. Some courts, such as here in Los Angeles County, have already decided not to even try to hold jury trials until next year. But elsewhere in California and the rest of the country, courts have decided to experiment with holding jury trials in the time of COVID. There are good reasons why some trials ought to go forward. Criminal trials and defendants have constitutional rights to a speedy trial, and plaintiffs in personal injury cases may be suffering with dire health conditions which require a trial preference. As one recent story in the ABA Journal observed, COVID has forced litigants, especially plaintiffs, to make agonizing decisions between indefinitely delaying a jury trial, settling in a lower number, or agreeing to a court trial by a judge. And if you keep the jury trial, you might have to wait, trial by Zoom, remotely, or risk indefinite delays until the pandemic is over. In order to hold jury trials while also ensuring the safety of participants, courts for months now have tried things like social distancing in the courtroom and requiring counsel to wear face masks and face shields. But a few courts have also started to experiment with completely virtual jury trials, meaning they're conducting the entire trial, including jury selection and voir dire, using Zoom or similar platforms. While it may not be realistic to delay all jury trials in the country until there's a cure for COVID or a vaccine, our research shows that jury trials during the pandemic pose problems for litigants and raise issues about the fundamental fairness of these proceedings. Litigants, defendants in particular, have started making legal challenges to these virtual trial procedures, but the courts generally have not been receptive to such motions, at least not at this time. So, what problems does the COVID-19 pandemic present for jury trials? These are the top 5 problems that we believe the courts and litigants are facing in trying to hold jury trials at this time, especially virtual ones. First is safety, jury selection, presenting the evidence, jury deliberations, and finally misconduct. Let's discuss them. First, safety. Problem number 1. It's already November 2020, and believe it or not, courts in this country have been experimenting for months with ways to conduct trials in accordance with coronavirus safety guidelines. However, as spokesperson for the National Center for State Courts told NPR, there's probably no better way to to spread the virus than putting anywhere from 50 to 300 people in a room together, sitting side by side for hours at a time. As the Washington Post article stated a few months ago, courts are rethinking virtually every aspect of their proceedings. Do courthouses need HEPA air filters to remove contaminants? Who can wear a mask during a trial? Should juror questionnaires include queries about health? On June 4th, the federal court system released its official recommendations entitled Conducting Jury Trials and Convening Grand Juries During the Pandemic. These recommendations include requiring face shields or face masks in the courtroom, using confidential jury questionnaires, inquiring about the health concerns and whether they or their families are vulnerable to coronavirus. Maintaining social distancing in the courtroom, which is hard. Placing markings on the floor so counsel know where to safely stand during the trial. Good luck with that. Nobody's going to be able to do it. Installing plexiglass or other barriers to protect the court staff and witnesses and counsel during trial. Deep cleaning of jury-occupied spaces after every session. Limiting the number of trials taking place in the courthouse, and allowing spectators to observe proceedings remotely to increase the open space in the courtroom. And moving the trial to more spacious locations outside the courthouse. Sadly, while we have all become used to these kinds of safety measures, they still raise issues of fairness. Some criminal defense attorneys say that requiring their clients to wear masks in the courtroom could make them appear guilty. How do you conduct a socially distanced sidebar? If jurors are seated throughout the courtroom, can they see or hear what is happening at counsel table? What if jurors can overhear conversations between a client and a counsel? Courts are considering having the court counsel and court reporter all communicate using wireless headphones while using white noise machines to mask any conversation. Think of the technical problems with that. Another proposal is to develop a sidebar app that allows lawyers to submit issues for the court to rule on electronically. Good luck. My typing isn't fast enough to be able to do that in a courtroom. Can and should courts be testing jurors for COVID symptoms? One federal judge in Texas told the ABA News in July she was requiring jurors to take their temperature at home each morning and report their results upon arrival. But the judge said the court just didn't have the capacity and could not afford to do daily testing themselves. Courts have been implementing these and similar measures for the past several months. And as I mentioned, with no end in sight to this pandemic, I expect these measures will be here in place for months to come, possibly even till a year from now. Problem number 2 is jury selection. Jury selection in the time of COVID poses really serious problems, and courts have been forced to come up with creative solutions. Taking a look at this, which is a picture of an actual courtroom, this is reminiscent, you can fill in the blank of what that looks like, but this is actually a jury box where they built individual spaces with plexiglass in front of the jurors and beside them. You tell me, is that the way a courtroom should look? And is this really going to slow down a virus if these people are together for day after day, hour after hour, for weeks at a time? As I mentioned in our last video, in Lake County, California, the court had to order prospective jurors to report to a former ice skating rink at the county fairgrounds for jury selection to maintain social distancing. And just getting prospective jurors to show up is a problem. Last week, in a civil trial we've been monitoring here in California, 300 prospective jurors were summoned, and only 45 appeared. That's a 15% appearance rate. Courts around the country are also experiencing with conducting jury selection remotely, without jurors ever coming to the courthouse. Instead, court and counsel have been conducting their selection in voir dire using Zoom. Really, that's happening. Virtual jury selection raises concerns. Juror privacy, Jury selection involves disclosure of jurors' names and other personal identifying information. Jurors are often asked very personal questions in voir dire, but parties still have the right to a public trial. To honor that right, courts are live streaming proceedings on public platforms such as YouTube. However, as other lawyers have observed, courts can't control the internet and can't control whether someone is recording the streamed footage or not. Jurors may not be all that forthcoming in voir dire if they know that their answers are broadcast around the world. Whether a jury representative of the community will be selected. Some criminal defense counsel have argued that virtual jury selection results in jurors that are disproportionately younger and more affluent in a higher economic status. This is because to even participate in a virtual jury trial, you have to own or at least have access to the necessary technology in your home. As 3 Texas lawyers argued in a September article in Texas Lawyer, virtual jury selection based on prospective jurors' access to technology can possibly lead to excluding large numbers of racial minorities from the jury pool. Whether counsel are hindered in their ability to pick a fair jury, the defendant, Honeywell International, in a case that we found recently argued in challenging a California court's plan for completely virtual voir dire, said, observing the subtle cues of demeanor is so important because it allows one to gauge juror credibility, which is important when evaluating whether a juror has concealed bias during voir dire. As a trial lawyer myself, I can tell you how critical voir dire is to winning your case at trial. And I have to say, I couldn't agree more that there are significant problems when this takes place. Presenting evidence is the third problem. How do we do it? California Civil Jury Instruction number 100 states it's important that all jurors hear the same evidence at the same time. This may be the biggest problem posed by virtual or remote jury trials, whether all jurors can see, hear, and understand the evidence at the same time, because we can't be there seeing what they're seeing on the screen. This can come up in many different ways. What if witnesses testify while wearing their masks? You know, being able to see somebody's face is very important in nonverbal communication. It lets somebody see and determine in some ways credibility. One solution is to require face shields instead of masks so jurors can see facial expressions. What if the Zoom connection is interrupted? You've been in enough Zoom depositions, mediations, or hearings, you know that some kind of interruption is going to happen at some point. It always does. This was a major issue in a trial last summer in a mesothelioma case called Ocampo versus Honeywell in Alameda County, California. There, the defendants challenged the trial court's proposed virtual trial protocol. Defendants argued that they would be deprived of a fair trial if there were to be interruptions in the internet, with the jurors not being able to be connected. Nonetheless, the judge said if somebody technologically drops off, then as soon as we notice it, we can put a stop and we can try to get them back. Good luck. If participants cannot reestablish the connection within 5 to 10 minutes, the court may take steps to pause the trial. You know, I respect the need, and all of us respect the need for certain trials to go forward. And I applaud judges for trying to take advantage of today's technology to see if that can be accomplished. But if there is a real possibility the presentation of evidence can be interrupted for 5 to 10 minutes or more, I think that raises real questions of fairness, regardless of whether you are a plaintiff or a defendant. Particularly in criminal trials or high-stakes civil cases. When I hear about these kinds of trials taking place, I have to wonder whether the technology is at the point we need it to be in order to hold fair trials. This morning, we heard that possibly there was a vaccine for this virus that may be coming out over the next 2 to 3 to 4 months. Probably our best chance to get back to a normal situation. The next problem that we have to face is jury deliberations. As I mentioned, 3 lawyers who all participated in an experimental virtual trial recently wrote an article in the Texas Lawyer magazine. What they said was eyebrow-raising. They said jury deliberations via Zoom were a huge concern, and the biggest difference between presentation of evidence and jury deliberations is that jury deliberations are supposed to take place privately and confidentially. How do we ensure all the jurors are able to participate in the deliberations without monitoring those deliberations? If one of the other jurors can't hear or see their fellow juror, is it another juror who fixes the problem? Or do they call someone? Big problem. But the lawyer's biggest concern was, how do we know the jury is not subject to outside influence? If jurors are already using a computer to connect to the deliberations, what's to stop them from searching the internet for answers or additional information? And if they do, how will we know? We probably won't. If jurors are physically present in the same jury room, we can expect the other jurors would see and report that. But that may not be the case if deliberations are done by Zoom. It's unclear how many jury deliberations via Zoom have been actually done and taken place. The jury in the Ocampo mesothelioma case in the Bay Area reportedly deliberated using a Zoom breakout room. And as the LA Times reported, Zoom deliberations took place in a Texas misdemeanor trial in August. But the problems raised by virtual jury deliberations are clear. If jurors are supposed to deliberate via Zoom, the court is in a catch-22. It has to monitor something it's not supposed to be monitoring. We have yet to see whether any legal challenges to virtual deliberations are sustained. The last problem is maybe the most obvious. How does the court police misconduct by jurors, parties, or counsel if the entire trial is done remotely? By this point, many of us are familiar with some of the more egregious cases, although it wasn't in a jury trial, where hackers actually interrupted a virtual Florida court hearing and streamed pornography into the courtroom. These are the expressions of the judge and one of the attorneys while it was actually going on. In May, a Texas case, during jury selection by Zoom, a prospective juror actually wandered off screen to take a phone call. He could even be heard talking on the phone in the courtroom, and there was nothing the court could do but wait for the man to stop talking. In our last video, I talked to you about what happened last summer in a case called Wilgenbush versus American Built Right in Alameda County here in Northern California. There, the defendant sought a mistrial based upon irregularities relating to the court's use of Zoom. The defendant claimed the plaintiff spoke with 2 jurors over the Zoom while the judge and counsel were in a separate Zoom room talking. According to the motion for mistrial, plaintiff was heard speaking with 2 jurors about how he set up a virtual Zoom background on his computer. The defendant argued the plaintiff intentionally and subtly created juror empathy through the conversation that took place. But at the end of the day, the court denied the motion for mistrial, ruling the defendant had not shown it was deprived of a fair trial. In the Ocampo versus Honeywell case in Alameda County I was just talking about, it was reported in the media that Honeywell filed a notice of irregularities complaining of inattentive jurors, including one who was emailing from a different computer and an alternate who was watching from bed. Hopefully these kinds of incidents are few and far between, but they did happen in real trials to real parties, and they will happen again. In the Wilgenbush case, where plaintiff spoke with jurors during the sidebar, the jury awarded a 7-figure verdict in the plaintiff's favor. It remains to be seen whether incidents like these will lead to verdicts in virtual trials being overturned on appeal. Challenges to virtual trials. Some parties, in particular both criminal and civil cases, have taken it upon themselves to challenge virtual trials. They brought legal challenges to trial by Zoom. From our research, they have generally been unsuccessful. From what we're seeing, trial courts are taking the position that they must do all they can to avoid unnecessary delays of jury trials. In California, judges have stated that the courts were closed for weeks or months due to COVID, and now they have to reopen. Jury trials must restart, even if they have to be done virtually. As I mentioned, this is not the view of the Los Angeles County Court, which is pausing trials until next year. Last month in New Jersey, a criminal defendant challenged virtual jury selection on these grounds, and the appellate court affirmed the procedure. In the Ocampo case here in California, I talked to you about the defendant Honeywell filing an interlocutory appeal challenging the trial court's prospected virtual trial protocol. The appellate court rejected the request as premature, stating, although Honeywell raises serious concerns, at this point they are speculative rather than concrete. The virtual hybrid trial went on forward in Ocampo, and after 2 days of deliberating in a Zoom breakout room, the jury actually returned a defense verdict for Honeywell. However, there has been a recent development. Last Friday, in a case in San Diego County called Overland, the judge ordered the jury trial with remote appearances by some participants, and the California Supreme Court granted the defendant's request for a writ of mandate and ordered the trial court to show cause why the trial should not be stayed. That's a big deal. Right now, the California Supreme Court has said that they needed to step in and examine the fundamental nature of whether you can really get a fair trial in a totally Zoom-type trial. So, we'll continue to monitor that situation. It's probably going to be resolved in the next couple of weeks. At this point, appellate courts appear to be deferential to trial judges in fashioning virtual trial protocols and are holding the defendant's concerns about virtual trials, while serious, are speculative at this point. Remains to be seen what's going to happen. So, our team is continuing to monitor developments on virtual trials and how trials are impacted by COVID-19. We're also sending with this video our updated written report on the status of court closures in the California federal courts and the California Superior Courts and state courts in the major Southern California counties. As always, if you have questions about any case anywhere, please feel free to call. So, we're ready at any time, anywhere, to help you if you have a problem with a trial. We have the technology to do it, and you have to try the case. If the judge says you have to go, you have to go. So if you need any help on any of those trials, please don't hesitate to pick up the phone and call. Happy to help. So until the next time, stay safe and healthy. Goodbye from Los Angeles.